Hello, everyone, and welcome. My name is John Harkins. I'm the Events Associate for the French American Chamber of Commerce New York chapter, and we are happy to welcome you to our webinar, Legal Updates for U.S. Businesses, Labor, Pension, and Employee Benefits, presented by Hinman, Howard, and Kattel Law Office. Just a quick word before I hand this off. The French American Chamber of Commerce's mission is to provide the opportunities, experiences, and understanding that empower successful business relationships between and for members. The FACC New York chapter counts a mosaic of 1,000 members, representing sectors from tech to food, finance, and other professional services. These members have complimentary access to digital events featuring top industry experts and leaders, as well as personalized member-to-member introductions, access to the FACC member directory, and of course, you'll be able to connect with other member attendees of this webinar. This webinar will last about an hour with around 45 minutes of presentation and then some time left at the end for questions and answers. As always, this presentation's recording and slides will be available to all attendees after the fact, so don't worry about missing a thing. I'm now going to hand it off to Nir, who is Special Counsel at HH&K, to introduce the firm, our speakers today, and give some more info on topics we'll be covering. Nir?
Thank you, John. I'd like to thank our webinar host, the French American Chamber of Commerce New York chapter, for making today's webinar possible. On behalf of Hinman, Howard, and Kattel, or HHK for short, we hope that all of you are in good health and spirits, and we appreciate the opportunity to connect with all of you and provide important information and guidance during these unprecedented times. Throughout the pandemic, HH&K has remained fully operational, and our attorneys have been working hard to assist our clients. The firm offers the expertise of our big city counterparts combined with the personal attention and client-friendly fee structure of a smaller local firm. With a geographic footprint in 5 states, New York, New Jersey, Pennsylvania, New Hampshire, and Florida, our attorneys are on the ground and know how to navigate any applicable local, state, and federal laws and regulations. As a full-service law firm, we have lawyers with decades of experience and expertise in nearly all aspects of the law. At HH&K, our clients and their goals come first. We value strong relationships that we have with our clients, some for the better part of a century. We concentrate on the requirements and regulations affecting companies throughout the business life cycle and counsel our corporate clients on a variety of issues they may encounter, including regulatory, transactional, and litigation matters. We have the ability to provide legal expertise on virtually every issue our clients may encounter, not just today, but well into the future. I encourage you to contact me directly if we can be assistance to you, your family, or your businesses. The firm's motto is peace of mind since 1901. Peace of mind that comes from knowing that you have put your problems in the hands of capable attorneys who offer creative solutions that are tailored to your needs. We hope that the information that my capable colleagues provide today will also offer you some peace of mind. Before I introduce my colleagues, a quick update regarding PPP, a program that I'm sure many of you have taken advantage of. The SBA has extended the safe harbor repayment period for PPP loans to May 14th, 2020. This safe harbor is intended to permit businesses that took PPP loans and have concerns regarding their good faith certification that the current economic uncertainty makes the loan request necessary to support the ongoing operations of the business. The SBA is expected to issue additional guidance on this, but it's also worth noting that any employer that repays their PPP loan by the safe harbor deadline will be treated as though they had not received the PPP loan for purposes of the employee retention tax credit. Again, I encourage you to contact us directly if you require assistance or have any questions. With that, it's my pleasure to introduce my colleagues, HH&K partners, Dawn Lanouette and Thomas Conlon. Dawn is the chair of HH&K's Labor and Employment Practice Group and sits in the firm's main office in Binghamton, New York. During her nearly 2 decades of practice, she has counseled employers on all aspects of the relationship with employees, from recruitment to termination. When the relationship sours, Dawn represents employers in state and federal courts and before administrative agencies. Her experience includes successfully defending clients before the Division of Human Rights, the Equal Employment Opportunity Commission, the Occupational Health and Safety Administration, the New York State Department of Labor, and the U.S. Department of Labor, as well as the National Labor Relations Board. Tom is the chair of HH&K's Pension and Employee Benefits Practice Group and sits in the firm's main office in Binghamton, New York as well. He has nearly 3 decades of experience advising clients across a broad section of industries regarding employee pension and welfare benefit plans, executive compensation, and a variety of other labor and employment, tax, and corporate matters. I'll now pass the baton to Dawn so that we can begin the first leg of this webinar.
Thank you very much, Nir. We're very excited to be with you today. Before I can talk, the New York State Bar requires me to say that this presentation is not intended to be legal advice. It's for information and hopefully educational purposes only. It may be considered attorney advertising, and you should not rely on it as legal advice. Please contact an attorney to discuss your specific situation. When we looked at the questions that came in response to having this webinar, a lot of them dealt with the question of workplace safety and what should employers be doing about workplace safety. So I'm going to start there, and I want to start first with the people who are telecommuting, because it certainly looks like the reopening plans, or if you're in a state that's already open, the opening plans still call for a number of employees to work from home and telecommute. So one of the first questions, and one of the questions I get most often, is how do we know, what does OSHA say about telecommuting? What about safety for people at home? And it's great that OSHA already had guidance about this, and their guidance really is that they encourage you to allow telecommuting by employees, and they encourage maximum safety flexibility for employers. But they aren't going to go look at home work sites. They don't conduct inspections there like they do in other work sites. So they have issued some guidance. The first one is, what happens if somebody gets injured at home? And the question is that injury work-related? And they give a couple of examples. One being that an employee is injured using some kind of equipment that the employer put in their house. And in that case, they said, yes, the injury is work-related. The second example they gave is somebody is injured because a dog barks and the person trips. And they said that injury is not work-related because it was caused by the dog barking or being startled. Similar with a doorbell, they gave as an example, that would not be work-related. So the basic answer with regard to home-based work for safety considerations is, whatever you as the employer supply, whether that's a computer equipment, whether that's some kind of office particular equipment, you are responsible for injuries that are caused by that equipment, but you are not responsible for injuries that are caused, say, if the worker takes a load of laundry down the stairs and trips while they're doing so. Those kind of home injuries. With that in mind, what should workers do? You should have a telecommuting employee agreement. And that should cover a number of things, including safety. So from the safety perspective, the thing you want to include is, if you're giving computer equipment, for instance, you would want them to agree to plug that computer equipment either only into your specified surge protector or into a designated outlet. For instance, you don't want people turning a 2-prong outlet into a 3-prong outlet to plug your computer in. First of all, it isn't safe for your equipment, but it's also not safe for them. So you do have some obligation to ensure any equipment that goes home is kept safe. The other things that should be in a telecommuting agreement are timekeeping practices and overtime rules for non-exempt employees. That's really important for non-exempt employees. Exempt employees, you can have them work anytime you want. The expected hours of work for each employee and the expected rest and lunch breaks. If you are in a state that requires lunch breaks, that requirement hasn't gone away. So you need to have the employees sign off on their understanding that they have to take that half hour every day. You'll also want to include the procedures employees will use to communicate with supervisors and others. And you want to train supervisors about when they can communicate with employees. So especially those non-exempt employees, employees who are paid hourly and subject to overtime. You don't want the supervisor calling them at 10 o'clock at night, because then you're going to owe employees for that time worked. Other considerations for telecommuting include cybersecurity. You may have to update your cybersecurity if you've never used web portals before, or you don't have a virtual server area. You also want to consider physical security. If you have somebody working at home with either medical records or private documents, you want to ensure that the agreement addresses whether they have locked those things up at the end of the day, that they shouldn't be left out. You want to address how your equipment is used from a cybersecurity perspective. Do you want them to agree not to let their family members use the equipment? A lot of kids are out of school right now. Can their kids use their laptop for their schoolwork? Those are things you should have in there. And then you want the agreement to be specific to the circumstances for employees who are going to be working from home. And what I mean by that is, if you don't normally have employees work from home, don't use you're going to be okay because you're going to create a specific agreement. But if you have a standard telecommuting agreement, you will probably want to use something else for this circumstance. And that's because you may have employees working from home who don't qualify under your standard telecommuting agreement. All right. Reopening or staying open if you are in one of the states that is not yet closed down. We here in New York are still closed for another week. But what should businesses be considering about whether they should be open or not? There is a lot of guidance out there. The CDC has issued interim guidance. OSHA has some guidance and regulations. And of course, each individual state will have its own executive orders. CDC's guidance is on that. That is right there. I just put the links in so you have them when the webinar goes out in case you want to look at them. So those things include questions about, should you reopen? Are you in a community no longer requiring significant mitigation? Meaning, are you in a place where either the rates are declining or not increasing in significant amounts? Would you be able to limit non-essential employees to those from the local geographic area? If you live in a place where people commute 45 minutes, an hour, 2 hours to get to work, that might be problematic. If your business requires a lot of air travel, that's going to be a consideration about whether you should be reopening. And then, do you have protective measures in place that meet whatever standards you need to meet, whether that's allowing for telework or spacing people out or using protective equipment? So CDC recommends that these are the steps you should take when opening or reopening a business. Promoting healthy hygiene practices, that's that hand washing. My office had the hand washing video playing for about 6 weeks, over and over and over again on a loop in the elevator. It was quite annoying. Intensifying cleaning and disinfecting. Do you have a cleaning protocol in place that meets the OSHA and CDC guidelines? If not, you need to get those and get that in place before you have employees coming back to the workplace. Do you have no large events? Obviously is still the general rule. Canceling non-essential travel. So if you were planning on sending a bunch of people to conferences, I was really looking forward to San Diego this summer. That's not going to happen anymore, at least not from my workplace. But you need to have plans for that. They recommend you should space out seating more than 6 feet apart, stagger work times. We live in an era of the open office space, and while it has some advantages, one of the great disadvantages is it does not really promote distancing in the way that other office spaces might be. So you will have to make decisions about what you have to do with that open office space. Restricting use of shared items and spaces, and then training all staff. You're going to hear me talk about some of these a little bit more again. Here are some safeguards that the CDC recommends for monitoring employees. Encouraging employees who are sick to stay home. And this is really an important part of reopening or staying open working. Because if we have sick employees in the workplace, they're going to continue to reinfect people. Establishing routines, monitoring absenteeism, and having flexible time off policies. You need an action plan if staff members get COVID-19. And then you'll want to have some communication channels for employees. And I'll talk more about those in a minute. OSHA has put out an entire booklet, and I put the link there, that talks about what you should have in place. And they really want you to have a plan, what they call the infectious disease plan, a written out plan before you reopen or stay open. And the reason this is important is because OSHA is probably the major way that enforcement against employers will occur. Most employees cannot sue their employers. They live in states where workers' compensation bars lawsuits, either entirely or mostly. And so a lot of lawsuits against employers for catching COVID-19 is not likely. But OSHA is a federal organization, and they can inspect and cite and fine people in all 50 states. So they are the ones that I think probably we have the most concern about meeting their standard. Their first requirement is that you conduct a risk assessment. The second is that you have an infectious disease plan. The third is that you have appropriate modifications and safeguards. And finally, that you have a communication plan. We're going to talk about each of those. How do you perform a risk assessment? Well, you first need to assess what are the risks to employees for contracting the virus. And that could be my employees have significant contact with the public, or my employee works in shipping and receiving, has contact with boxes, or this employee who's really only internal has very little risk for contracting the virus. Then what are the risks to the public for contracting the virus at your place of business? And finally, what are the risks to your business from opening that? And I've talked about some of those. Once you perform that risk assessment, then you're going to move on to create your infectious disease plan. And that plan needs to have four things. You can go ahead and go forward on the slides. Engineering controls, or what we call physical controls, administrative controls, safe work practices, and personal protective equipment, or PPE. So for engineering controls, the OSHA has set out a number of things you can consider. Barriers between your employees and between your employees and the public. I know a number of my clients have installed plexiglass, either to complete their drive-through windows or their walk-up windows if they're a food servicer. Banks and financial institutions have installed greater amounts of plexiglass to keep barriers between themselves and clients. So you may need to consider barriers. Maybe you have a receptionist and you need to put a barrier around the receptionist. High efficiency air filters or other ventilation changes, and then changes to the workspace to create distance. Can you move desks further apart? Forced traffic patterns. If you have been shopping lately, you might have seen some of those, either arrows saying you only go up and down this row, or stop and start lines. The goal is to keep people 6 feet apart, of course. Once you've done all you can for engineering controls or physical controls, then you're going to move on to administrative controls. And those include a good sick leave policies and practices. That might include, if you are an employer with fewer than 500 people, reliance on the Family First Act. It might include creating your own sick leave program. Social distancing and minimizing contact with the public are important administrative controls. So if you normally have a bunch of contact with the public, as lawyers do, you might want to go to Zoom meeting or GoToMeeting or some other system for conducting a lot of those meetings. You might want to encourage people to do conference calls instead. We're going to talk about training and education and communication in a minute, and then limiting of shared work equipment or coming up for procedures for that shared work equipment. Think about copiers, telephones, whatever it is in your workplace that multiple people use, how will you disinfect it between uses? After you've considered, part of administrative is policies and procedures. That includes visitors and others to the work site. Will you do temperature checks? Will you have short surveys or questionnaires for people to fill out? Those are both permissible, but you need to understand how you do it and how you maintain those records. You want to encourage employees to self-monitor, and you want to encourage employees to stay home. You might want to have procedures in place to identify and isolate people who show up to work sick anyway. What will you do if that happens? How will you get them out of the workplace? And then OSHA and other organizations have recommended that you create a workplace pandemic coordinator and pandemic team. Now, I know in some places that's going to just be your HR director, and in smaller businesses, that's going to be the same person that wears every other hat. But you want to have in place somebody who is in charge of monitoring the updates for your state and from the federal government and ensuring that you are able to comply with them. And the final thing that you will need is a closure plan, because we have learned now that you may have to close on short notice. What do you do about training? I'm recommending to clients that when you bring people back into the workplace, you're going to need to have some short kind of meetings with them, or you're going to have to do it via some kind of web conference before they come back to talk to them about what they need to know in the new workplace. For instance, if you've installed one-way traffic hallways, how do they know that? Where do they see that? If you have a new policy that says, you know, every time you use the copier, you need to wipe it down, you need to train them on that. So you need to have that conversation with your employees. If you are going to use PPE, personal protective equipment, training is required for that. So OSHA requires you to educate employees. Here's some more things you can train them on good, safe work practices. That includes hand washing and use of hand sanitizers. Plan for workers to stay home if they're sick. How will you do social distancing, discouraging the use of the telephone, the desk, other people's information, and regular cleaning. Here's just some more suggestions in case you need other ideas of things you can do. We can go on. The final way in which you can help employees is personal protective equipment. That includes putting out gloves, goggles, face shields, face masks. Respiratory protection, you need to have actual training to use. But for a lot of us, we're in states now where face masks are going to become the requirement generally. Just a few other ideas. Following the CDC cleaning protocols, watching for increased infection, and having a protocol if somebody becomes sick. So the final thing I'm going to talk about is the communication plan, and then I think I just have a few slides on unemployment, and I'll do those pretty quickly. So every employer needs to have a communication plan if you're going to be open during the crisis or reopen. Regular communication with employees, we found, is really key. You want to normalize the fact that you are sending employees notices. And the reason you want to normalize that is there's virtually no chance that you will reopen and not have someone get infected. They will become infected with the virus, and you will need to either notify other employees or notify the public through the Department of Health. And if you want to have normalized that process so it's not so surprising to employees. So a few things you can do is if you are serving the public, you should contact your local Department of Health and find out what they want to know, if you have any cases of infection and when they want to know that. You should prepare template communications for alerting employees and the public. You can do that now while things are quiet so that you're not doing that during a time of panic. We can go. There's just some things you can communicate to employees: social distancing strategies, options for working remotely, good hygiene and disinfecting procedures, and that kind of information. Next slide. One of the big questions I've been getting is, will people come back to work? And that's, you know, a question that is partly a money question because of the additional funds available under unemployment, and partly a fear question. So let's talk a little bit about what factors might affect that. We have employees who have risk factors, and you may ask them to come back to work, and they say to you, I don't want to come back either because I have asthma, or I have some other risk factor, or my age concerns me. Remember that the Americans with Disabilities Act, a request not to come in or work from home is a request for accommodation, and that requires an employer to perform an analysis of whether they can grant that reasonable accommodation. Same thing if you send somebody home from the job because you suspect they're ill, you will need to assess whether you can grant them a reasonable accommodation of staying home. There is leave available under the Families First Act, 80 hours of pay, and then additional time in some circumstances. Many states have put in pandemic leave of various kinds, so you could look to those statutes for monetary assistance for employees. But the first question is going to be, can you accommodate what they're requesting, whether that's work from home or something else? Those don't apply to childcare, which is a whole nother issue. Next slide. Several employers, when you mentioned the PPP at the beginning of this, the Paycheck Protection Act, and they're looking for loan forgiveness, right? So you may be one of those employers who has a loan and you're looking to maximize that forgiveness. and you have employees who are out there on unemployment. And the problem is if you call them back, they're going to make less. We have gotten some guidance now that says that if you make an offer to return the employee and they don't come back, that will not count against you for purposes of the Paycheck Protection Act forgiveness, which is helpful. Some employers still aren't ready to ramp up yet, and so that's a consideration. Loan forgiveness also doesn't apply to employees on federal sick leave or emergency family leave act. Again, they don't count against you for forgiveness, but you're not going to be able to count the amount you spend on them for your forgiveness. So what are some of the options employers have considered in trying to get that maximum forgiveness? There's an option to pay some kind of hazard pay to employees, an additional amount for working through this. You can treat it as a 1% loan, which is what it was intended to be. So you may choose to keep some of it, and that's a pretty good rate. And it's access to cash if you think you'll need it down the road in the next year. And then some employers have talked about giving bonuses to employees. I have said many times now in the last 2 days, I think it's crazy that we think we can reopen the economy unless we have childcare available. But in many states, and even under the federal government's plan, childcare is one of the last things to be opened. And so employers in states where there's been closures or partial closures that have not reinstated childcare are going to have to deal with the fact that many of their employees are simply not going to be able to return to work because of childcare issues. There's flexible work hours. You can go back for just a second. Families First Act, I just want to remind you that that has childcare in it, and there is a relaxation in many states of the daycare standards, so that may help as well. Okay. I'm going to turn it over to Tom now to talk about the retirement plan changes.
Thank you, Dawn, and thank you everyone for joining our presentation today. Before we get into the crux of my presentation here on the various changes that we have to be aware of, one thing I wanted to piggyback off of a theme that Dawn was developing earlier about bringing employees back to work, particularly those employees who you have furloughed or otherwise laid off during the interim. One thing you have to remember is that when they come back to work, all the normal rules would apply in terms of cafeteria plan elections, whether they're eligible to participate in your 401k plan, your health plan. If they've been out of the plan long enough where they have to go through the waiting periods again, those all will apply. Those have not been waived. So as you start to consider bringing folks back, remember, particularly with cafeteria plan elections, that if someone has gone out and returned within 30 days, you basically have to restart their cafeteria plan elections. They can't elect something different than they had before. All right, so let's move on to the changes that the various, in particular the CARES Act, made for employee benefit purposes. One is that this is only for defined contribution plans. There's an optional the ability to amend your loan program for those affected by the COVID-19, whether that's because they were furloughed or because they were laid off, their work hours were reduced, or you're an owner of the business and the business is experiencing reduced profitability and cash flow because of the pandemic. Those COVID affected individuals are eligible to take loans from their 401k plans up to the lesser of $100,000 or 100% of their account balance. The normal rule for defined contribution plan loans is that you can take up to 50% of your account balance or $50,000, whichever is less. This extends the loan amount, but that's really the only thing that it changes with regards to the loan, unless the maximum term is still going to be 5 years for the loan. You're still going to, it'll be repaid at the normal interest rate. There's no special interest rate for repayment of those loans. If it's a residential real estate loan, you can still take it out for up to the 30 years if your plan allows that. But this provision is one, if you're going to extend the loan provisions and make these COVID loans available to folks, you're going to have to amend your loan procedures to provide for that. The standard loan procedure that most of us have adopted for our 401k plans is not going to be sufficient for this. You're going to need to add this to it. And again, this is optional. We'll get to another one of the optional provisions in a moment, and I'll come back to that. But right now, for those of you who have defined benefit pension plans, a dying breed for sure, but there are still a number of them out there. The 2020 required contribution date, I don't know why that's cut off there, is extended to 2021. So any of the payments that you would have had to have made, your required contributions for the year after you've compared the assets of the plan to its liabilities, are deferred until 2021. That may impact your testing and other things for the FTAP certifications, but you should work with your actuaries through that, and they will be able to assist in any of the adjustments that need to be made because of that. The other optional provision or provisions that a plan can adopt has to do with distributions. You can, as the IRS has done with other federal disasters, and Katrina in particular, and that's the one that the IRS keeps harking back to in terms of where it's patterning its guidance on how these provisions should be administered on. There's a special, you can amend your plan to add a special COVID distribution. It's open to the same folks who would be open to take the extended COVID loan if they were so, if your plan allowed it or you wanted to allow them. But it's that same group of COVID impacted folks who can take a distribution of up to $100,000 without penalty, including the early distribution penalty if they're under age 59 and a half, and the usual tax withholding for those distributions. The CARES Act creates the legal fiction that these distributions are trustee to trustee rollovers and therefore not subject to the withholding rules. So it's a nice feature. The CARES Act also provides that the income from those loans will be, or those distributions, I should say, will be recognized over 3 years. And we've gotten some preliminary guidance, informal guidance from the IRS that says, look at the Hurricane Katrina provisions. And basically they would say that a third of your distribution amount will be recognized in income in 2020, in 2021, and 2022. During that same 3-year period, the participant, in addition to to recognizing the income, the participant will also be allowed to repay the COVID distribution without penalty. And again, it'll be treated as a trustee to trustee rollback into the plan, so that there won't be any issues with withholdings or other taxes. If you have taken that distribution and you've recognized it in income in the first year, and then you repay the whole thing in the second year, the participant's then going to have to file an amended tax return to take that income out of their taxable income for 2020, assuming that they repay the entire amount. If it's prorated, the IRS has said that if they're paying part of the distribution back, that they will come out with some guidance for us to let us know how we're supposed to treat that in terms of the repayment and need to refile your income taxes for that year. Another provision, and I'll pause here on this one for another moment. The COVID distributions and the COVID loans provisions are optional. Plans do not have to adopt them. When the CARES Act first came out, however, all the TPAs of the world rushed into getting this stuff ready for folks to access it on the first day that the CARES Act became effective. And some of them gave folks a very limited period in which to decide whether they're going to adopt any of these provisions or not. It was like, if you don't let us know by midnight on Sunday, Monday morning, these provisions will be available to your participants. And so during that whole period, it was a lot of back and forth with clients who are, most of which took the position, well, these are great things that we can offer our employees. We're not sure any of them are needed yet. Is there a time period in which we have to adopt these? These provisions are only effective through the end of the year, but you can adopt them at any time between now and the end of the year and take full advantage of them. So that if we get through this first round of closures and reopenings, and it appears that your employees may need either the additional loans or the COVID distributions because of the financial hardships they've suffered, you can put those in place anytime between now and the end of the year. They get the full advantage of all the provisions of both the special loan provision and the special distribution provision. One other thing I want to mention on loans is that the CARES Act has granted an extension of the due dates for any outstanding loans for, again, those people that fall into the group of COVID-affected individuals, particularly those who may have been laid off, furloughed, or had their hours reduced. They're excused from loan payments from now through the end of the year. Those loan payments would start up, if they take advantage of this, would start up again in January, and the period of time between their last loan payment and now, the interest that accrued will be added to that, and then the loan will be re-amortized over its remaining term, so that there will be 5 years of repayments plus whatever the term in which the loan payments were suspended, so that the loans will run for a little longer than 5 years if you're going to the maximum, but the code is making a specific exception for that. We haven't had any IRS guidance on this. Most practitioners are reading this as that loan deferment provision is mandatory and takes effect without the plan sponsor having to adopt it. Others, and some initial informal guidance from the IRS, seem to indicate that they consider this to be optional as well, so that the employer has the option to adopt that for its employees. And some of them have made that decision at the present time, and others are taking a wait and see look on that as well to see what their employees want to do with their outstanding 401k loans once they get back to work. All right, we'll move on to the required minimum distribution waiver in 2020. The required minimum distributions for those who were 70 and a half before December 31st, 2019, or who turned 72 as of January 1, 2020 or thereafter, who would normally be required to take what we call a required minimum distribution. Those are waived for the year. And similar to the loan repayment modification, the statute reads as if this is mandatory, that everyone's loan required minimum distributions are waived. The IRS, and we're looking for final guidance on this, but the initial informal guidance is suggesting that this is optional as well, and that an employer can adopt, can decide not to take advantage of that RMD deferral and require those for its employees. I think we'll have to stay tuned on that one. And before we get to the last slide in our presentation on the changes here, some guidance that came out last week, and we got some clarifications earlier this week. The IRS and the DOL have jointly extended various employee benefit plans, times to respond for various things. The first is that if you had any employee benefit filings or anything else that was due between April 1st and July 15th, those are automatically extended to July 15th. The key is, at least at this point, and I apologize for my barking dogs in the background, it must be mail time. So that if you are on a calendar year, your 5,500s will still due July 30th, unless extended to October 15th. And at least as of now, that hasn't changed. So that if you've been putting off thinking about your 5,500s for the year, you'd better get started working on those again, because they're still due at the end of July unless you extend them. The second extension of time periods has to do with HIPAA special enrollment, COBRA elections, COBRA notices and benefit appeals. The IRS and DOL jointly issued guidance that basically says that we have to disregard the time that elapsed between March 1st, 2020 until the period that's 60 days after the end of the national emergency is declared by the president. And we have to, in effect, what happens is that any deadlines during that period, whether it's for HIPAA special enrollment, COBRA elections, or anything else, that period doesn't count. It's the statute of limitations, in effect, is told during that period, so that we pick back up whenever that 60th day after the emergency declaration ends. That period is disregarded, and you would start running your time periods for HIPAA special enrollment, for delivering COBRA notices for impacted folks, for folks making their COBRA elections or payments that may have fallen during that period. And more importantly, benefit claims and appeals are also held in suspense during that time, so that if someone normally would have 180 days to file a health plan appeal, for example, the 180 days doesn't start running until the suspension period is up. And that was all that I had for terms of employee benefits updates and things to think about.
Well, thank you both, Dawn and Tom. We obviously very much appreciate you coming on, speaking to these topics, and giving a very informative presentation. We do have a couple of questions, as we are right on time. This works perfectly. So I'll just go through them now, and we'll get to them. So if we paid EEs that we do not want to lose, but who are not coming back to work because of fear, can that be hazard pay for PPP forgiveness?
Yes, you don't even have to call it hazard pay. You can give them leave under the statute and pay them. The amount that you're paying them, even though they didn't come back, will count towards your PPE forgiveness, and they will continue to count as a equivalent, whatever you're paying them, if that's full-time or part-time, towards the number of people you've kept employed.
Okay. And another question is, what if full-time employees had a 25% reduction in their salary? Does that apply?
Yeah, so you want to talk about that, Tom? There's
Sure.
Really two things that affect forgiveness. So
yeah, when you think about the PPP loans, you have to think first, there's the amount that you're given that you calculate in accordance with the statute, and that's the amount of your initial PPP loan. We then have this 8-week forgiveness period during which whatever costs that fit into the correct bucket are able to be forgiven from that loan, and those kind of all go into another bucket of the forgivable amount. From the forgivable amount, they run 2 tests. One is the 25% of pay test, and if employees have had their pay reduced by 25% that wasn't restored by June 30th, that would, the amount of there will be a deduction from the amount forgiven because you didn't pass that test. And the other test is the bringing back the full-time equivalents, so that you are, at or above the level that you were at in full-time equivalents during whatever the look-back period is that you picked under the CARES Act. And that will also then, when they run that calculation, will come up with a number that will be deducted from the amount able to be forgiven. And so that those deductions and any amounts that you didn't spend during that period will become the loan at 1%.
Okay. And just a final question here before we let you all go. Just a question about hazard pay or bonus payment under the PPP to obtain loan forgiveness. Has the SBA agreed on that?
I believe the SBA has said that as long as you are paying the money under to the employees, it does not have to be for actual work performed.
Correct.
You know, whether you call it a bonus or you call it hazard pay because you're paying people an increased rate of pay, or you're calling them, you know, you're calling it, it certainly is the case you can give them leave and any payments for leave. So even if you have your own leave program, you do paid vacation and somebody takes paid vacation during that period, that counts towards forgiveness. Health insurance counts towards forgiveness. So, you know, in that $100,000 cap, you know, this might be important for some employers. While that applies to the monetary amount of compensation, it doesn't apply to the other things. So if you also pay health insurance for an employee who's getting that max amount, you can still do that and it would still count.
Yeah, and retirement plan contributions also count under the PPP for forgiveness. So particularly if for employee stock ownership plans or folks who would normally be making their yearly profit sharing contribution, you know, at or on or before the date on which their tax return is due for 2019, those amounts would also be eligible to be forgiven under PPP.
Okay, well, I think we're gonna stop the questions there, let you all go. But Dawn, Tom, and Nir, I'd like to thank you so much. And before I let the audience go and let everybody get on with their day, I just would like to mention that we have a couple webinars coming in the coming weeks. We are speaking about urban mobility, and we are also taking on the lighter side of things, talking meat with Ariane Daga. Again, Tom, Dawn, thank you so much for taking the time. Nir, thank you so much for helping facilitate all of this. I know this was very helpful for all our members, and I'm sure that if they have any questions, they will take advantage of the fact that your contact information is in the slides. To our attendees, thank you for coming. We expect to see you on our coming webinars within the next coming weeks as well. And as I mentioned before, the recording and slides will be distributed to all the attendees tomorrow. So thank you so much again, once more, Dawn, Tom, Nir. It was an absolute pleasure, and hope to speak soon.
Thank you.
Thank you.
Take care, everyone. Bye-bye.
Bye now.
Thank you.